Good evening, friends. They say that when there is will, there is either the will of the persons to come to you or you have many relatives and friends. And they also say that once there is will, there's bound to be disputes. But today's session is with collaboration of Trivikram and Associates to understand what are the manners in which we can avoid the disputes while executing the will. Yesterday morning, Mr. S.R. Suryanarayana Rao had shared with me one write-up, and we found that write-up was quite interesting, and a lot of people would gain from that, not only professionals, judges, as well as the students of law and common man. And we requested Sir to share his knowledge on this particular interesting topic, and also so that there is less of litigation. Like we all know that we are speaking about mediation pan-India, so that there is a lot of litigation is reduced. And if we understand these nitty-gritties from Mr. Suryanarayana Rao, I'm quite sure that it will facilitate the process not only for the persons in whose favor the will is executed, and even otherwise, those who feel that they have been denied the fruits, they can also understand that since that will has been executed in such a manner that there will be less disputes. Today's session will be in that particular manner, the journey. And we will ask Mr. Trivikram in the end to take up the questions which the people at large will be watching this session on YouTube as well as in the chat box. Over to you, sir, and thank you for accepting our invite.
Very good evening, all of you. I have a very interesting question to answer in today's lecture. The preface to the lecture will be probably much longer than the actual subject. And that is absolutely necessary in order to correctly understand the solution I have given in the article which I have penned. The first and the foremost thing which we should understand is that there are 3 documents which require attestation. They are, number 1, the will, the gift deed, and the mortgage deed. These are the only 3 documents which require to be compulsorily attested. As far as the will is concerned, a reference may be made to section 63, clause C of the Indian Succession Act. This is how it reads. The will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by the direction of the testator, and has received from the testator a personal acknowledgement of his signature or mark, or the signature of such other person, and each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the time, and no particular form of attestation shall be necessary. This is how it is defined in section 63 of the Indian Evidence Act. Then we may make a reference to 2 provisions of the Transfer of Property Act also. That is, section 59 refers to how a mortgage should be executed. This is how section 59 reads, where the principal money secured is 100 rupees or upwards. A mortgagee other than a mortgage by deposit of title deeds can be effected only by a registered instrument signed by the mortgagor and attested by at least 2 witnesses. Therefore, a mortgage deed other than a mortgage by conditional sale, it shall be by a registered instrument, and the same shall be attested by at least 2 witnesses. Then we can make a reference to section 123 of the Transfer of Property Act, where This is how it reads. For the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least two witnesses. Therefore, both a mortgage deed and a gift deed referred to in Transfer of Property Act, they are compulsorily attestable. A sale deed, on the other hand, is not a compulsorily attestable document. Then we can make the word attested is also defined in section 3 in the interpretation clause. This is how the word attested is defined in section 3. Attested in relation to an instrument means and shall be deemed always to have meant attested by two or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has seen some other person sign the instrument in the presence and by the direction of the executant, or has received from the executant a personal acknowledgement of his signature or mark, or the signature of such other person, and each of whom has signed the instrument in the presence of the executant. But it shall not be necessary that more than one such witness shall have been present at the same time, and no particular form of attestation shall be necessary. So, therefore, by a reference to these Transfer of Property Act and Succession Act, it is very clear that these three documents require to be compulsorily attested. Then, by a reference to these sections, we understand that these are the essential requirements of attestation in respect of all these three documents. One is the testator or the executant should sign the document in the presence of the attestors. That's the first requirement. Then the attestor must sign the document in the presence of the testator or executant, or in case where the testator or executant has not signed the document in his presence, the attestor should have obtained a personal acknowledgement from the testator or executant of having subscribed his signature to the document. It is not always necessary that the attestation of both the attestors should take place at the same time. See, what I mean is the attestor should sign the document in the presence of the testator, having seen the testator sign the document. Suppose the will is prepared, the testator has already signed it. Yeah, and he brings the document to the attestor and says, yes, I have subscribed my signature to this document. Kindly attest this document. In such a situation, there will be valid attestation of the attestor who has received a personal acknowledgement. Then he can take the document to some other attestor and also tell him that he has put his signature to this document. The attestor who receives an acknowledgement from the testator can sign the document as an attestor, and then also it will be validly attested. So, therefore, what should be clearly in mind is these factors should be clearly in mind when you are about to justify the execution of the will when it is questioned in a court of law. The wordings in the affidavit in examination in chief should clearly disclose all these contents. This we have got to keep it in mind. Then the Bharatiya Sakshya Adhiniyam 2023 has a few provisions with regard to proof of a compulsorily attestable documents. They are section 69 to 70, and the principles laid down in this section are broadly as follows: that a document which is required by law to be attested shall not be used in evidence until one attesting witness at least has been called for the purpose of proving its execution, if there be an attesting witness alive, subject to the process of the court and capable of giving evidence. So therefore, if we should prove the will without summoning at least one attestor, the will cannot be proved. So therefore, it is absolutely necessary to summon at least one attestor if both the attestors are living and subject to the process of the court. So the one attestor who is examined not only should speak about his attestation of the will, but he should also be capable of speaking about the attestation by the other witness also. Then only the requirement of proof of will would be there. In many situations, what happens is that the uh, that the attestors would be dead. If both the attestors are dead, or both the attestors cannot be found or identified at all, then what is the procedure to be followed is mentioned in Bharatiya Sakshya Samhita 2023. And it clearly says that if both the witnesses are dead or cannot be summoned to the court, in such an event, you have got to prove that the signature of the executant is in his own handwriting, number one. The signature of one of the attestors is in the handwriting of that attestor. How we can prove this? Suppose the son of the testator is there, or some other person who is acquainted with the signature and handwriting of the testator may be there. You can summon those persons to say that they are acquainted with the handwriting and signature of the testator, and this is the signature of the testator, by which the signature of the executant testator could be proved. Then, with regard to the other witness also, the same procedure could be followed. Normally, what is done is a close relative, like the wife or like the son, who would have seen their husband or father subscribe their signature to the document, they would be summoned and they would be in a position to identify and the signature of the testator or one of the attestors. In such a if such an evidence is given, then the will stands proof. Then an exception is carved out in section 68 of the Evidence Act. Not the evidence, the Bharatiya Sakshya Samhita now. I would just read that particular section in regard to the proof of a compulsorily attestable document which is registered. In fact, that is contained in section where where a document, in fact, that is a proviso to section 67. This is how the proviso reads. Provided that the section 67 speaks of proof of execution of document required by law to be attested. Then a proviso uh, makes an exception. This is what the proviso says. Provided that it shall not be necessary to call an attesting witness in proof of execution of any document, not being a will, which has been registered in accordance with the provisions of the Indian Registration Act, unless its execution by the person by whom it purports to have been executed is specifically denied. So therefore, this proviso does not apply to a will. This proviso applies only in respect of a gift deed and a mortgage deed. If the gift deed and mortgage deed is registered according to law and the executant has not execution of this document, then there is no necessity to prove this document by calling an attestor as a witness to this document. This proviso has absolutely no reference to the will, and it does not apply to the will at all. This has got to be kept in mind. Then, one of the most important questions that would always be in our mind is Section 69 of the Evidence Act. And this is what Section 69 reads. The admission of a party to an attested document of its execution by himself shall be sufficient proof of its execution as against him, though it be a document required by law to be attested. So therefore, this section 69 of the Bharatiya Sakshya Adhiniyam very clear the executant of the will, mortgage deed, or a gift deed has during his lifetime made a clear admission of the execution of this document, then there is no need to summon the attestor to prove the document. So therefore, how we can come into this particular section, how the testator can take precautions under section 69 during his lifetime uh, so as to record his there are various, in fact, this provision has been subject to matter of three decisions. The earliest decision in this behalf is a decision reported in 2003, 3, all 61. It's a judgment of the Bombay High Court Nagpur bench. The names of the parties are Rukma Bhai, Vithobaji Wardwick versus Narsuram. In this case, the question was that the will had been admitted by the testator, and arguments were advanced that the will is not properly proved. Then the division bench, then they make a reference to a few earlier decisions of the Bombay High Court and the Allahabad High Court. In fact, a particular portion is called out in paragraph 14 of the judgment, which reads as follows. I am of the opinion, observed Atkinson J., that 20 Calcutta 190 and 38 Allahabad, Allahabad page 1, which decide that an admission under section 70, that is under the old Act, Evidence Act, which is now section 69, that an admission under section 70 of the Evidence Act 1892 to be admissible in evidence can only apply to an admission in fact made in the course of legal proceedings, then pending before court of justice, cannot be supported on principle or authority. Mr. Moropan also relied upon the decision of the Allahabad High Court in 44 Allahabad 127. It is, however, clear from the report of the judgment in the said case that the admission on which reliance was placed by the party seeking to prove the document had been made in the pleadings in the case itself. And the case thus clearly fell within the scope of Section 70 of the Evidence Act. Even so, the learned judges proceeded to observe that they were not prepared to hold that Section 70 is limited to an admission made in the course of the suit, but they also pointed out that it was immaterial for the purpose of the appeal to consider that question. The earlier decision of the Allahabad High Court in 38 Allahabad was not cited and has not been considered in this case. In our opinion, this was important. In our opinion, under Section 70, it is only if a party is shown to have made an admission about the execution of the document in the proceedings where the document is produced, the proof of produced, the proof of attestation that, in our opinion, under Section 70, it is only if a party is shown to have made an admission about the execution of the document in the proceedings where the document is produced that proof of attestation can be dispensed with. If the contrary view is accepted, we apprehend that it will tend to render Section 68 inapplicable to most, if not all, documents which are registered. Section 70 of the Indian Evidence Act 1972, therefore, clearly is an exception to general rule provided in Section 68 of the Act. So therefore, the admission, so therefore the Bombay High Court holds that the admission need not be in the very same proceedings. The admission could be in any other earlier proceedings of the case. In fact, a reference to Section 70 does not make any reference to admission in any judicial proceeding. It only refers to an admission. The admission could be in a judicial proceeding. The admission could be by way of an affidavit. The admission could be by way of a declaration registered before a sub-registrar. So if all these admissions could be very clearly proved, then Section 70 or the present Section 69 would be applicable. In fact, this very principle is also affirmed by the Karnataka High Court in an unreported decision, that is WP number 102067 bar 2024, Sarojini versus Yellappa Kempanna Bidegawad. In fact, in this decision, a reference is made to sections 67, 68, and 70 of the Bharatiya Sakshya Adhiniyam. A reference may be made to paragraphs 17 and 18 of the judgment. This is what Justice Suraj Govindaraj has stated in the judgment. There are two short paragraphs which would be very relevant. They are: once a testator has admitted the execution of a will in a proceeding before court and pleadings are filed, I am of the considered opinion that there is no requirement to further establish the authenticity of the will in terms of Section 67, 68, 70 of PSA 2023. Since the testator himself has categorically admitted the execution, veracity, and the contents of the will, and has herself produced the will in the said suit. Thus, I answer point number one raised by holding that if a testator were to admit the execution, the contents of the will in a court proceeding, there will be no requirement, is what's important. There will be no requirement to further prove the execution and veracity of the will in terms of section 67, 68, and 70 of the BSA 2023. In fact, very by Karnataka High Court in another decision reported in 2025, 1 Karnataka Law Journal, page 480. It is a judgment by Ananta Ramanath Hegde J. The names of the parties is Shiromani versus Godavari. In this uh, in this judgment also, a reference could be made to paragraphs 59 to 66, wherein the lordships have discussed all these provisions and have come to the conclusion that where in a in some previous court proceedings, if the will is admitted by the testator during his lifetime, there will be no need to prove its execution or attestation. The will is deemed to have been proved, and therefore, if we have got to find out how the testator can take necessary steps for assuring that his will is not questioned after his lifetime. I have been a lawyer for the last 54 years. I have conducted lots of cases, both on behalf of the propounder of the will and also the persons who have questioned the validity of the will. In fact, normally it so happens that the persons who draft the will are not clearly aware of how the will has got to be executed. In fact, what happens is in many documents, the attestor's name only is mentioned. His address is not found. We are not able to identify the the attestors at all in many cases to summon them to give evidence in the case. And moreover, one name is there, either Muniappa or Narayan Swami. We do not know the name of the father. We do not know the identity at all. Therefore, when a lawyer drafts a will, the will must clearly contain the all particulars relating to the attestor also, including his Aadhaar number and mobile number, so that he can be correctly identified at the time when the will is questioned on a future date. Then it also happens that all witnesses who are examined, they are not very intelligent and they are incapable of understanding or even remembering what transpired at the time of execution of the will. Therefore, their evidence sometimes would not be sufficient under section 67 for proof of the will. Therefore, even an honest registered will would fail in cases where the attestors do not give proper evidence before a court of law. These are very practical difficulties. And it also happens many times that the attestors of the will, though they can be correctly identified, they may not help, they may not even support the proof of the will at all. They could have been brought over by the other side. Many witnesses demand a higher fee for proof of the will where very, very valuable properties are involved. And it is in normally, as defense counsels, when a will is brought before us, we will normally ask the defendant who wants to oppose the will to find out whether the attestors would support the execution of the will or whether they would support the defendant. Even in a genuine case, if both the attestors should come and say that the will, that it is their signature, the will was not signed in their presence. The beneficiary brought the will to us, and they asked me to sign the document as an attestor, and we have attested it. Even in such cases, the will would positively fail. Therefore, the only panacea which I have thought of to give the testator an assurance that the will, if questioned after his lifetime, would certainly be upheld, could only be done by the testator himself filing a suit before the court during his lifetime. In fact, in my article, I have given two annexures. The first annexure is what is the nature of the suit that could be filed by the testator? Who would be the defendants in this suit? And how this suit should be framed? In fact, Mr. Chetrat, is it possible to take out annexure A? Hello? This is how, in fact, in my article, which is reproduced in published by Daksha Legal, I have given a pro forma plaint that could be filed. The pro forma plaint, the plaintiff would be the testator himself. And this is, in fact, I have drafted this pro forma as if I have filed a suit before the court. The plaintiff is myself, that is S.R. Suryanarayana Rao, advocate, 76 years, residing at number 263 Subrayapet, Chickballapur. The defendant is nil. There is nobody who is assigned as a defendant. The first paragraph is about the address of the parties. This is what I state in the second paragraph. That is, the plaintiff is a practicing advocate at Chickballapur. Though he is presently 76 years of age, he is still in active practice and attending the course. The plaintiff is therefore in a sound disposing state of mind. So that is to show that even on the date when the suit was filed, the testator is in a sound disposing state of mind. The second paragraph would say that the plaintiff has executed a registered will. It may be a registered will or it may be an unregistered will. Dated so and so. If it is registered, give particulars of the registration of the will. And suppose sometimes the will is kept in a sealed cover in a sub-registrar's office, you can also mention it. If the will is kept in your custody, you can also say that the will is in my custody. If the will is given to the custody of a third person, that can also be stated in paragraph 3 of the plaint. So therefore, the execution and custody of the will is clearly stated in paragraph 3. Then in paragraph 4, because I have myself drafted the will, this is how I say. The will aforesaid is drafted by the plaintiff himself. That is, so if it is drafted by a different person, give the name, address, and other particulars of the person who has drafted the will. Then this will is attested in the presence of the plaintiff by the following two attestants by name. So therefore, you say that the will is attested in the presence of the testator, that is the plaintiff, and the names and addresses of the attestors may be given. And it may also say that the attestors are known to the plaintiff. The attestors have also signed this will in the presence of the plaintiff. The plaintiff wants admission of due execution of the will to be recorded by the court, so that proof of execution of the will by examining the attestors of the will is dispensed with if this will is questioned in a court of law after the lifetime of the plaintiff in view of section 69 of the Bharatiya Sakshya Adhiniyam 2023. So therefore, all the requirements of admission, attestation, custody, everything is stated in the plaint. Then the deposition of the plaintiff in support of the allegations made in the plaint may kindly be recorded in open court. That is the next paragraph. Then the cause of action for the suit, in fact, no declaration is sought in respect of the properties. The only relief sought for is wherefore the plaintiff prays for a decree declaring that the plaintiff has himself admitted the due execution of the registered will dated so and so, referred to in para 3 of the plaint in order to meet the ends of justice. So therefore, the only declaration sought for is that the plaintiff has himself admitted the execution of the will. This is all what I have sought for. The cause of action for the will is the date of declaration made by you. The declaration is made on the date when the suit is filed uh, by way of the plaint. So therefore, the cause of action arises on the date when the plaint is presented. So therefore, because you are not seeking any relief in regard to the property, there is no need to show what properties are covered under the will and who are the beneficiaries under the will, so that you can maintain the secrecy of the will also. If you are inclined to produce a copy of the will, a copy of the will can be produced. If you don't mind, seek about the secrecy of the will, that could also be done. A copy of the will could also be produced. And as far as the valuation is concerned, the valuation is not in respect of the properties of the will. The value would be only a notional value. So therefore, under section 24 of the Act, you make a notional valuation. You can say that the relief sought for is valued at rupees 1,000. You can pay a court fee of rupees 75 and file the suit before the court of the municipality. If you value it above 5 lakhs, you can file it before the court of the civil judge, senior civil judge also. Then there is no need to ask for any other incidental or subsidiary relief apart from declaration. A suit for bare declaration would also be maintainable. Yeah, in fact, a reference may be made to section 34 of the specific relief act, which refers to a suit for declaration. This is how section 34 reads. Any person entitled to any legal character as to any right, as to any property, may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such a suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief, then a mere declaration of title permits to do so. In this case, no further declaration is necessary. There is no defendant in the suit. And therefore, no claim for any further relief is available to the plaintiff. Therefore, a suit for bare declaration The legal character is that your admission of execution is recorded by the court. That is the legal character which is required to be declared by the court. Therefore, if such a declaration, then naturally it would come within section 70. You have the plight, you have the deposition, you have the judgment of the court, and the beneficiary would produce this document. If the will is questioned after the lifetime of the testator, there is no need to go to the testators and beg them to give evidence. And therefore, if we should adopt this method, we could see that the will, even if questioned at a later date, is actually upheld by the court without any difficulty to the beneficiary. There is one other, in fact, in some situation, it may so happen that the will is executed at the time when proceedings are pending in a court of law. So, in such a case, an application could be made under Section 151 CPC to request the court that the admission of execution of the will be recorded. An IAB filed with the court without asking for any final order to be passed at the IA. In fact, I have also produced, given an read to my article where I have given the nature of the application where the will is executed during the pendency of the proceeding or wants the will to be the will to be upheld without examination of the attestation. In fact, this is the application which I have shown in Annexure B. After the cause title, application under Section 151 filed on behalf of either the plaintiff or the defendant. The testator may be either the plaintiff or the defendant. For the reasons mentioned in the accompanying affidavit, the plaintiff defendant humbly prays that the registered or unregistered will dated so and so, executed by the plaintiff or defendant, a copy of which is herewith produced, be recorded in order to meet the ends of justice. If you want to produce a copy of the will, that is best. Produce a copy of the will along with the application. Then the affidavit, this is how the affidavit would read. I am the plaintiff or defendant in the case. That's the first paragraph. The second paragraph is, I have executed a registered or unregistered will in respect of the properties belonging to me on such and such a date. And this is give particulars of the registration of the document if the will is registered, and say I have also produced a copy of the will along with this application. I have executed the aforesaid will voluntarily without any compulsion from anybody. I am presently in a sound disposing state of mind. I have got the draft of the will by Sri, give the name of the person who has drafted the will. And I have affixed my signature to this document in the presence of the attestors by names so and so. Mention the name of the attestors also. All the attestors are known to me, and I have also affixed their signature to this document in my presence. I have executed this will with the object of avoiding any disputes in regard to my properties after my lifetime, and also in view of the pendency of this suit. As I do not want the will executed by me to be disputed after my lifetime, I have filed this application so that the execution of this will be recorded by the court and no dispute in this regard is entertained. Therefore, I humbly pray that the admission of execution of the registered bar, unregistered will, dated so and so, may kindly be recorded in order to meet the entity. Simply file the application. No order is required to be passed on this application. Get this application recorded in the order sheet. That would be sufficient. So therefore, in a situation where a suit is pending, you can file an IA. In a situation suit is pending, you can file a suit for declaration of title. In fact, I have found, in fact, we cannot predict the way judges think when it comes to a proof of will. In fact, I have come across cases where the judge says that this particular person had an attack of epilepsy, or he had suffered a paralytic attack, and he was suffering from blood pressure, he was suffering from diabetes, and for all these considerations, they think that his mind was not quite sound to execute a will. In fact, in one of my cases, very curiously, in fact, the document is a registered document. It is executed by a retired government servant. She had, her husband had died. She had no children at all. She had kept an attendant to take care of her during her lifetime. She made a disposition of these properties in favor of that attendant. In fact, the will executed by this lady was challenged by a distant relative of her husband. The court said that in the will, she has not made a reference to her legal heirs. There are no nearer legal heirs at all. Probably she did not even know that some distant relative of her husband would be her legal heir. Then, therefore, the court listed that this is one of the suspicious circumstances. The second suspicious circumstance was that she went with a walking stick to the sub-registrar's office, and that she was wearing a nightie at the time when the document was. In fact, I failed to understand. In order to, in fact, I had led evidence to show that after the execution of the will, she had herself gone to the bank. Admittedly, she had drawn her pension amount also from the bank. If these factors very clearly disclose that she was in a sound disposing state of mind. Yeah, and many judges do not know the difference between physical ill health and mental ill health. And the medicine has so advanced that a paralytic stroke will not affect your mental state. I have been a diabetic for the last 35, 40 years. I have blood pressure. If such yardstick should be applied, any person, a judge may hold that I don't have a sound disposing state of mind, and therefore I cannot execute a will. So therefore, see, it is very difficult to predict the mind of the judges. And the witnesses, in many cases, are rustic witnesses. They are unable to understand the concept of how a will ought to be executed. Some stray answer somewhere is taken out and thrown out of it. Therefore, in many cases, the will is held to be not proved, even in cases where the attestors support the document. Therefore, see, I try to find out from the precedents whether whether we can find out any legal method by which the testator during his lifetime could assure himself that his will be given effect to after his lifetime without any difficulty to the beneficiary. Therefore, I thought if there is no suit pending, he could make an application. he could file a suit for declaration. If a suit is pending, he can make an application that very soon. Therefore, in fact, an affidavit also may be sufficient, and the execution of so those things can be challenged. If a suit is filed, and if your statement is also recorded before the court, then all the requirements for proof of the will. Therefore, this is yesterday. In fact, there are large number of cases in all the courts in which the proof of the will is the main subject which which would be required to be determined, right from the lowest court up to the highest court. And a device like this, an intelligent testator, would probably save the will from being seriously contested. And therefore, from my own thinking, maybe this method may not be absolutely a correct method. Some refinement may be required in this regard. A new legislation could be brought in uh, by the suggestion given in this article, so that contest with regard to the bills could be safely avoided. So therefore, I would, in fact, there is one decision of the Supreme. In fact, I would also make a reference to one other recent decision of the Supreme Court. It's a recent decision of the Supreme Court reported in 2025 SAR Civil, page 968. Metapalli Nusumbai versus Metapalli Muttaya. A reference can be made to one particular paragraph in the judgment, wherein their lordships say that a registered will carries a presumption. This is what their lordships have said in this decision. The distribution of the properties as per the family settlement regarding which oral evidence was led, and the registered will is almost in the same proportion. The will is a registered document, and thus there is a presumption regarding genuineness thereof. The trial court accepted the execution of the will based on the evidence laid before it. As the will is a registered document, the burden would lie on the party who disputed the existence of the will, who would be defendant Muttaya in the case, to establish that it was not executed in the manner as alleged, and that there were suspicious circumstances which made the will doubtful. In fact, the Supreme Court has no doubt said that a registered will carries a presumption. In fact, there are earlier decisions which very clearly say that even if the will is admitted by the other side, even if the will is not denied by the other side, even if, even if the will is registered, then the will has got to be proved as required by Section 67 of the Indian Evidence Act. There is no provision anywhere which attaches presumption to the execution of a registered will. In fact, no discussion is contained in the judgment as to how the judges have arrived at a conclusion that there is a presumption in regard to a registered will. What is the basis, legal basis? The Supreme Court might have said so. We are bound by the judgment, and all the courts below are also bound by the judgment because it would be the law of the land. However, justifiable reasons should have been given in the judgment as to why the court has arrived at a conclusion that a registered will carries a presumption, and it is for the other side to disprove the execution of the will. In fact, there's in another decision of the Supreme Court, all the requirements for proof of will have been very clearly stated. And I would only read that particular paragraph in regard to the execution of the wills. In fact, it is a decision reported in 2023 SAR Civil 1097, Meena Pradhan versus Kamala Pradhan. In fact, they the following principles from another decision have been taken. The entire bills has been put in the judgment. Therefore, I would prefer to read that particular paragraph. The first requirement, the court has to consider two aspects. Firstly, that the will is executed by the testator. Secondly, that it was the last will executed by him. This is the first requirement. The second requirement is it is not required to be proved with mathematical accuracy, but the test of satisfaction of the prudent man has to be applied. Number three, a will is required to fulfill all the formalities required under Section 63 of the Succession Act. That is to say, in fact, they have reproduced the entire Section 63. Then, then fourth requirement, for the purpose of proving the execution of the will, at least one of the attesting witness who is alive, subject to the process of the court, and capable of giving evidence will be examined. Number five, the attesting witness should speak not only about the testator's signature, but also that each of the witnesses had signed the will in the presence of the testator. Then the next requirement, if one of the attesting witness can prove the execution of the will, the examination of the other attesting witness can be dispensed with. When one attesting witness examined to prove the will fails to prove its due execution, then the other available attesting witness has to be called to supplement his evidence. Then there is one other thing which may also be kept in mind. There is Section 90 of the old Indian Evidence Act, which says that a document which is 30 years old and which is produced from proper custody, in such a case, the signature and every part of such document which purports to be in the handwriting of any particular person is in that person's handwriting. That in the case of a document executed or attested, that it was duly executed, attested by the person by whom it purports to have been executed. In fact, the section by itself does not execute the will. However, the Supreme Court has said, in view of the fact that sections 67 and onwards prescribe a particular mode of proof for in regard to execution of the will, this section 90 does not apply to the wills. However, it applies to a gift deed and a mortgage deed. If it is 30 years old, there is no need to examine the attestors of the will or the persons connected with the execution of the will, and mere production from proper custody would be proof of that registered document. Therefore, with this, I would only conclude that if I have made a proposal which occurred to my mind, which would be a panacea for avoiding dispute in regard to the wills. In fact, I have penned this article in the memory of my father. I practiced with my father for about 10 years. He was my mentor. He has guided me in the profession very well. He was a non-graduate leader. His understanding of the law was extremely good. His English was good. Readings were thirst and to the point. I owe everything, even my thinking in law, to his training. And therefore, I offer my obeisances at his feet. And therefore, I close this lecture. Thank you. Thank you all.
Thank you, sir. There's
Thank
one. It says no property has been mentioned in the will. Can
Yeah.
the executor add ancestral joint property of the propounder of the will in the probate petition on his own to show that the proprietor bequeaths such ancestral joint property?
Even in respect of an application for probate or for letters of administration, according to me, there is no need to mention the properties which are covered under the will. In fact, if a probate is of the will, it does not relate to the title to those properties at all. And it only speaks about the proof of the will after the death of the testator. The testator is not there to speak about its execution. There also you will have to examine the attestors. You will have to prove the execution of the will as required by section 67. Therefore, see, in this suit, you can mention the schedule if you want. Even if you don't mention the properties in the schedule, it does not matter at all. Even according to me, even a probate petition or a petition for grant of letters of administration, there may not be any need to mention the properties in the schedule at all. And even there, you cannot avoid examining the attestors. Therefore, getting a probate of the will or getting a letters of administration subsequent to the death of the attestor, it will not help you in avoiding the examination of the attestors, at whose mercy you will be.
Yes, sir. There's another question.
What's the next question?
Yes, sir. What steps should be taken to verify the testimonial capacity of the person drafting a will and how it is documented?
See, when you file a suit before the court and when you are examined before the court, your deposition in the court will be there. The court can ask you some questions to find out whether you are mentally sound or mentally not sound. Your examination before the court would itself justify that you are in a sound disposing state of mind, apart from what you have stated in the plaint itself. Therefore, the question of whether the testator was in a sound disposing state of mind or not would not arise at all after the suit is decreed. There is no need to issue summons in the case. There is no need to issue a public notification because except the plaintiff, no other person is going to be affected by the decree. So therefore, the date on which the suit is filed, the plaintiff could be examined. On the very same date, the judge can make a judgment. It's a fast, inexpensive remedy that I have suggested.
So, last question. What constitutes undue influence and how it can be avoided during the will of the drafting and execution?
Pardon?
So, what constitutes undue influence and how it can be avoided during the will and execution?
See, when the question of undue influence or fraud in regard to execution, the burden is squarely upon the person who alleges fraud or misrepresentation in regard to the execution of the will. The burden is not upon the propounder of the will. The burden would be on the person who sets up fraud or misrepresentation in regard to the execution of the will. In fact, when you come before the court and say, I have voluntarily executed the will on my own accord without any compulsion, you also give a deposition on oath before the court. Therefore, such objections also would be avoided by following this procedure. So, therefore, all questions that are raised in regard to the execution of the will by a person opposing the will would be answered by a suit of this nature. No other precaution need be taken by the testator. The testator can sleep comfortably, can die comfortably, being assured that his will be upheld on a later date.
Thank you, sir, for taking us to a very interesting topic. And we are quite sure that the legislature would take into queue the suggestion made by you. On behalf of the team of Beyond Law CLC and Recruitment Associates, we are thankful for sharing your knowledge on our platform. Namaskar.
Thank you, sir.